Welcome. Let me introduce our panelists for this first presentation of the day. It's called Filing a Proper Motion, Stipulation, and Settlement Agreement. We have Judge Dietz, Attorney Tracey Hyde from Panama City, and Attorney Berry Stein from Miami. Judge Dietz is a JCC in Sebastian-Melbourne. I've known Judge Dietz for a number of years. In fact, probably over 25 years ago, we had some cases against each other so long ago, I don't remember anything about the cases except that I won every case. Is that your recollection of Judge Dietz? No, seriously, Judge Dietz was an excellent attorney, an accomplished mediator, but he's even a better JCC. I consider Judge Dietz one of my mentors along with Judge Walker, and I appreciate all the help that he's given me. If you want to see an impressive bio, go on to OJCC's website and read Judge Dietz's bio. A class individual. He even wrote me a handwritten congratulation letter when I got this job. And who does that? Besides my mother. But JCC, putting Judge Dietz in the highest of company there. Tracey Hyde and Berry Stein, I'm going to talk about them together. I don't think they'll mind. They have a deep mutual respect for each other, but they practice law a lot alike. They're both very effective, very knowledgeable. They're both extremely ethical and extremely honest. Berry is currently on the Workers' Compensation Board Certification Committee and on the Rules Advisory Committee. Ms. Hyde has served on both committees as well. They're both board certified. Ms. Hyde, this is not well publicized, but in 2017 was the board certified attorney of the year in the entire state of Florida, not just in workers' compensation. I don't know if that's ever been done. I've never known that to have been done by any workers' compensation attorney. It's quite an accomplishment. She is, I understand, the only practicing board certified attorney in Panama City. In fact, she's the only board certified attorney from in the area between Tallahassee and Pensacola that's practicing workers' compensation law. Attorney Stein is a practicing attorney in Miami. Even though he's that big city cosmopolitan type attorney, he's down to earth. He knows about fishing and country music. So he can speak Southern as well. So I'm excited about this panel. It's been an honor and privilege to serve as a JCC. It's also an honor and privilege to have this panel with us today. And again, our title is Filing a Proper Motion, Stipulation, and Settlement Agreement. We felt that this topic was vitally important. Because certainly as JCCs, we need to know exactly what you as practitioners want us to do. We don't know the case nearly as well as the attorneys. So when you file a motion or stipulation, we need to know exactly what you're requesting. Certainly the parties are normally bound by stipulations, especially pretrial stipulations. And in my opinion, what the practitioners do with motions and stipulations will almost always affect, to a great degree, your client's chances of prevailing at final hearing. So it's vitally important what you do. And if it's not done right prior to a final hearing, the die may be cast as far as your chances of success or not success. Judge Dietz, you like to add anything to the importance of this topic?
Well, I think it is an important topic because it oftentimes is the first time the case is looked at by the judge. And it's in the context of procedural events going on. Oftentimes I find that the parties will spin off in the direction of arguing the case, of talking about the case, when in reality, that's really hard for the judge to do, first of all, because all the evidence hasn't been brought together and submitted at that point. And yet now the judge is trying to make a procedural ruling. So I think the topic is a very important one. I appreciate being invited to be on the panel. I appreciate Judge Moneyham's revisionist history regarding litigation in the past. But nevertheless, I think we can hopefully accomplish a lot today, covering a lot of different topics.
Okay, thank you. First of all, we're going to talk about basic rules for all motions. Number one, we had use plain English. And the first question is for Judge Dietz. Can you have a valid motion that does not contain one Latin term?
Well, I'm sure there's some practitioners that probably question whether I can speak English, let alone Latin. Outside of res ipsa loquitur and in banc, I'm not sure I know any Latin. But the challenge that we have is trying to interpret what's been written in motions to understand exactly what's being asked for. And so certainly plain English, making it simple where it can be understood as to what's being asked for is really important. And oftentimes we find that different parts of the motion contradict each other. The title says one thing, the text says something else, the plea says a third thing, and the judge is left trying to figure out what's going on and trying to figure out whether it's something that can be determined and decided without having a hearing. Remember, a hearing after a motion's been filed and a response has been filed is supposed to be the exception, not the rule.
Correct. And next point of our outline is to tell the judge exactly what you want the judge to do. And Ms. Hyde, why is that important?
Well, you have to make sure that he understands what you're filing. Like Judge Dietz was just saying, sometimes the title doesn't seem to match what's in the body. And so when after you've gone through your motions and your paragraphs and you get to the end, you want to finish it with what you want the judge to do. Wherefore, please grant my motion, and this is why. And I'd like to say, Judge Dietz was saying, sometimes if the title doesn't quite match the body, you hope you get it right in the conclusion, but failing that. But like he said too, the hearing should be the exception, not the rule. And I don't find that to be the case a lot of times, is that as soon as a routine motion is filed, we're getting contacted to set hearings. And I don't see that rule being followed well. I mean, uniformly anyway throughout the state.
Right. And I think your point that it should be restated in the conclusion is very good, because you always want to look at the end of that motion and be confirmed it's exactly what the party wants you to do. I think it's very important. And if anybody else has anything.
There probably should be a caveat here. When I talk about any of these topics, I'm talking from my own experience in the middle of the state, the practitioner's experience at other ends of the state or in any other district may well be totally different. So certainly I hope that the attorneys, that Tracey and Berry will give us, what's happening in their districts. What are they seeing as they practice around the state? Both of them are statewide practitioners, and so as a result can bring a great deal of experience and commentary regarding the different practices of handling these things statewide.
Okay. And I'll let Mr. Stein address, if he wants to address that, but he can address the next question as well. The next question is, if you don't think the judge will grant your first request, should you list alternative requests?
There's a desire never to let the judge know you don't think you're going to get your first request. Motion practice in workers' comp is changed over the course of the years, and being succinct and direct about what it is that you're asking for is critical. If alternative requests make sense in terms of what's being asked for, then sure, you need to let the judge know that there are alternatives and these are the ones that you can think about. Remember, as we're sitting in the middle of, post-COVID world, much of this stuff is done online, and the judge is relying upon what it is we're presenting, and so is opposing counsel. And so it's important that you list out whatever you think may be there, even though your gut tells you it's a little reflection of the fact that you may think you're going to lose. The question is what the judge can do, and how does he mete out a proper result for everybody.
All right. And the next 2 points on our outline, advise the JCC of the factual basis supporting your request, as well as the legal authority supporting your request. And I'll throw that open to whoever wants to try to answer why those 2 points are important in a motion.
I struggled with this a little, the factual basis, because it seems to me that basic motion drafting is full of factual basis for your case. What I see lacking in times on the other side of the table is no cite in the initial paragraph of even the rule under which they're filing, or what statutory authority the motion is being sought. And sometimes I think it's just a case of, oh, I'll just throw anything out there and hopefully the judge can figure it out. So it seems to me that those two are very intertwined, that not only do you have to set forth sufficient facts for the judge to want to rule for you, or at least consider ruling for you. And legal authority, I think, always helps, because it's a lot easier for the judge to glance at a case you may have attached that may be obscure or he hadn't thought of or she hadn't thought of, than to just do a cite and then make the judge look it up. So I do try to attach my case law in addition to citing the legal support.
Okay. Anybody else have any thoughts on those two?
Well, let me give you two examples of the factual basis that's sometimes lacking. In a motion for an EMA, there is a dispute. Okay, great. That's the standard. And then there's no discussion as to what the dispute is. There's no citation to the medical record. There's no citation to deposition. There's a dispute. Sometimes they'll even tell me the body parts or what the dispute is about, but that's just a statement. That's not the evidence of the dispute. Another example is in motions for advance. I've gotten one sentence motion. Claimant was injured and claimant needs money. Okay, we'll probably talk about this at some other point, but what is the evidence that helps me to be able to identify, other than the fact I can recognize it's a motion for advance because that's what's in the title. So a lot of times when there's missing facts, the judge is left scratching their head, and I don't like to do that too much because there's not many hairs left, but trying to figure out what is going on here that leads me to need to take action right now. And unfortunately, that's what requires us to ask for hearings occasionally. It's just understand what's going on. And that's not the way it was designed or written as rules.
Okay. Is it important to focus on the subject of your motion as opposed to, and Attorney Hyde has already addressed this, trying to prove your entire case in a motion?
Yeah.
I'll address that to Attorney Stein.
I always like to craft a motion with the facts as Judge Dietz talks about and listing them out one to the next, to the next, to the next, so that they kind of add up, like the equation makes sense. And it helps you focus on the subject of what you're asking for. If in fact it's a motion for an EMA, then it's hard, if you're doing it piece by piece by piece, it's hard to miss any of those facts. And then of course I have to look back at the statute and make sure I'm tracking the language in the statute in order to accomplish the goal. By the end of the motion, I should be satisfied that that's in fact what it says. I also try to give myself a time where I walk away from my motion and then I come back and see if it reads the same way after that.
And I would think that'd be good practice for anything, especially a pretrial, to walk away and let it sit overnight and then come back to it. I know it's good practice for me as a judge to do that for an order. All right, and what about Judge Dietz? This is a question on that topic for you. How do you view a motion like, let's say you've got an 80 count motion when it should be a 5 count motion, and 75 counts of the motion are trying to prove the ultimate claim or the ultimate defenses in the case as opposed to the motion? How does that affect you?
Well, the more confusion I have as to what is being asked for, the less chance that there's going to be an immediate ruling, because all the motion is telling me in that scenario is that I don't have all the information necessary to evaluate it, which means I either have, first of all, we're assuming now, of course, that a response has been filed and that the time's gone for that. But now I have to make a ruling, or we have to have a hearing. And I find that a lot of times the hearing has to be set because I can't fill in the blanks as to what's happening. And I'll give you an example of that. Motions to compel or claims that the response has not been adequate. And yet there's nothing spelled out as to why it's not been adequate. Sometimes they'll say, well, they didn't give me an answer to number 7, 9, and 13 in the request to reduce. So I turn to 9, I turn to those numbers and I look at it, but I can't tell if it was an insufficient answer, meaning that they provided something, or if there was just no answer provided. And it doesn't say that in the motion. So again, I have to schedule a hearing in order for the attorneys to tell me what they filed. Oftentimes the responses are not attached, which of course, if there's a document that's been filed, it's supposed to be attached to the motion. I can't tell you how often there's missing motions, and if that's the issue, you know, that may get summarily denied immediately if there's no attachment and the motion references other pleadings. That, you know, that's clearly what the rule says has to be done. So the challenges of having to have a hearing just to find out what the facts are to me, misses the point of what the purpose of the pleadings were in the first place.
Okay, thank you. And working through our outline, I hope that everyone listening via Zoom will have a copy of the outline. If not, you can email me or contact me and I can send you a copy of our outline after the presentation. But the next point is remember the 3 C's. And the 3 C's of motion drafting, and really the 3 C's of any legal drafting, I think: clear, concise, and compelling. And I have to give credit, I got this from attorney Ed Kinberg, who's actually in Melbourne, Florida, is an expert in governmental contracting. But is it important to make our motions in any legal drafting document really clear, concise, and compelling? Attorney Hyde?
Yeah, I'm a big believer in say what you want to say and get the heck out. There's no point in belaboring. There's no point in adding paragraph after paragraph, just restating what you've already said. Length does not go very far to convince the judge that you're going to get what you want. So I am very short and to the point.
Okay. Any other comment on that?
Yeah, I'd just say I remind myself of the circuit court days when we used to go to motion calendars and you'd move down the table. If you didn't get your point out in a sentence or two, you pretty much lost. So, you got to present your motion like Tracey presents her briefs. Clear, concise, compelling.
Well, and to Judge Dietz's point too, and I'm a defense attorney for life, but and I guess it's a waste of judicial economy to just summarily deny those motions that don't tell you what they want to say, and then they have to refile it. And so I guess it's judicial economy to just set the hearing, but that kind of stuff just really would really bug me as a judge.
Okay. All right. Moving on to basic motion rules. 60Q 6.115 is where these are contained in. The motion title should describe the exact relief requested. Is that important? Judge Dietz?
Well, the problem here is a single point that's being made is easy. The problem is when there's alternative arguments, and then tucked away on page 5, the next to last line is a motion for continuance. And the title doesn't say anything about that. And the problem is whatever is being requested, to me, needs to be in the title so that there's a quick checklist to verify that what's being asked for has been addressed by the judge in making a ruling. Now, in theory, that should also be in the first paragraph, and theoretically, it should be in the conclusion at the end. But a lot of times, those 3 things don't match. The title doesn't match the first paragraph. The first paragraph doesn't match the conclusion. And that's where the challenge lies.
Okay. And sticking with you, Judge Dietz, next question is it important that practitioners cite to a docket location as to any attachments to a motion?
Well, the rule says that it should be summarily denied if it's not done. So getting to Ms. Hyde's point, that's the purpose of the rule.
Okay. And then I'm going to ask both attorneys, how do you fulfill the requirement under 60Q 6.102.12 or 6.102.12 to personally confer with the opposing side before filing a motion? And I'll start with Attorney Hyde first, if you would.
Pick up the phone. In the words of my our former chair, Glenn Whelan, when he talked about a case at the comp convention a couple of years ago, and about how we shouldn't get into situations where we're filing motions for sanctions. Pick up the phone. And so to me, personally conferring means it's the attorney to the attorney, and there's case law that says that. I get really tired of an email from the legal assistant to my legal assistant. Do you object to this motion? I'm the attorney. Call me. So I pick up the phone.
Okay.
And hopefully I get, if I don't, I'll follow up.
On your desk? Is that a little logic up with the core there on your desk? Is that a phone? Attorney Stein.
Yes, that's my phone.
Okay. Attorney Stein, how do you feel the requirement
too? But I mean, pick up the phone. Personally confirm means personally confirm.
I work at odd hours, so it's not unusual for me to be typing at 3 o'clock in the morning and preparing a motion. So I don't hesitate to email that to opposing counsel. I will not file it until either I get a response or I have a history from that attorney of not contacting me back. And then I'm not adverse to making a phone call, especially if they've already gotten the motion. Then I can at least talk to them and find out. Again, historically, it's a question of whether or not you're getting cooperation. It's really wonderful when you have attorneys like Tracey and you know you're going to get responses. The problem is often that responses are not given, or that you're making an assumption that the other side is going to oppose something. It kind of annoys me when the motion gets filed against me and nobody ever contacted me.
Okay.
And the big challenge of this rule is that everybody forgets about the end of the sentence. And that is whether there's an objection to the motion. Because if there's no objection to the motion, the judge can enter the order immediately. And that's what the whole purpose of this rule is, to see if the parties can work it out and whether there's an objection. And I can't tell you how many times I get a motion that says that contact was made or suggests that one-way contact was made, but there's no information as to whether there's an objection, which means I'm left hanging. So immediately I'm going to have to wait the 15 days to see if there's a response filed. You know, that's just inappropriate. Tell me whether there's an objection. If there is not one, then the order is immediately entered, and the whole system works faster if we can get agreements between the parties regarding these issues. Now, I want to go back to the pick up the phone issue, because I think attorneys miss out on a point here. A lot of people say, well, they never answer the phone. Well, guess what? The same attorneys that don't answer the phone for you don't answer the phone for us when we're trying to call to schedule hearings and to do things. So we know what attorneys do not answer the phone. So if an issue comes up later in which the party makes the statement, I couldn't get a response back, we just sort of nod our heads, go, yeah, I know, because they never return calls. That's not the reputation you want as an attorney. The problem is that the people that this would apply to aren't watching this seminar, because usually it's the people that apply the rules properly that attend seminars that are supposed to help you be more efficient and to be more professional in presentation. Our challenge is that the people that need to be watching this aren't watching it. And so that's unfortunate, because so many of these things could be expedited so easily if parties would just respond, answer phone calls, talk about whether there's really a basis for objecting, determining whether there's really a dispute between the parties. I can't tell you how many times we get on for a hearing, and what's the first line out of the mouth? Well, we talked before you came on the line, Judge, and we've worked out a solution. Well, trust me, I've had to prepare for that hearing. I've had to review all the pleadings that have been filed, the motion, the response. I've set aside time. I've had to leave my office to go to the courtroom. I've had to set the computers up in the courtroom. All of this takes time, and I'm not asking you to be sympathetic to what our job task is, but the point is all of that could have been resolved if you just talk, because you tell me that as soon as the hearing starts. So, you know, to me, that's why this certification is there. Determine if there's an objection and see if you can work it out.
Okay. And Attorney Stein made an excellent point, and my question to his point would be, is it better practice to actually forward a copy of a proposed motion to the opposing attorney and let them read it, where they can tell you after reading it whether they object or not? Mr. Stein, start, since you brought that up, if you wouldn't, and I'll ask Attorney.
Again, because the motion practice tends to be directed to specific kinds of things, discovery that hasn't been provided, as Judge Dietz said, if you're detailed about it in the motion and you explain what was missing or that you have never gotten a response, oftentimes that will generate a response from the other side saying, we sent it to you. And you know, emails don't work perfectly, and the size of documents sometimes blocks the email that may have come. And if I get a response, then I'm not going to file the motion. And we're going to end up getting the documents that were provided earlier that I would have not known about had I not sent them the motion. So I think it generates 50% of the time a good response, because I've now clarified what it is I'm looking for. Or we've honed in on the issue and we've made it really clear about what it is that, you know, hasn't been responded to and needs to be.
Okay. Attorney Hyde, your
And there's a lot of collegiality up our way that I know Berry doesn't experience a lot in the South Florida area, but most, especially like in discovery requests, we'll get a email from the attorney or a letter saying, hey, we served a request to produce on December 1st. What's the status of the response? And like Berry says, we can either look in the file and say, oh, we already answered, or, oh, shoot, I forgot about that one. Let me take care of it to avoid those motions to compel. Because me personally, I hate motions to compel production. That there shouldn't be a need for it. You get 30 days to respond. If you can at least do a partial, you can let them know you're still working on getting some documents. But on other motions, I do send a draft to the opposing counsel, especially if it's something a bit more complicated, like a motion for summary final order or something like that, where I'll draft the motion and then send it to the attorney and ask them if they object. Simpler ones like a motion to continue or a motion to admit. Well, maybe not motion to admit. I usually send those too, but generally reach out. It's kind of like the good faith effort before the petition gets filed. Reach out and see, if there was just like Berry says, an email issue or something else that it can get resolved quickly rather than go in the motion to compel route.
Okay, thank you. The next question is for Judge Dietz. Is an order necessary for an unopposed motion, or I guess it could be a stipulation as well?
Well, the theoretical answer is no, it's not necessary, except there are certain carriers that will not issue a check without an order being entered on a stipulation. And so in those scenarios, I just need to know whether or not you need an order on the stipulation that's been reached. So in those scenarios, we're happy to enter an order approving the stipulation. But the first time I had a party come back in and say, well, Judge, 3 weeks ago, we sent you the stipulation and you didn't enter an order. And the rule doesn't say I'm supposed to enter an order if it's a stipulation of the parties. They said, well, we can't issue a check without it. Okay, so now when we get a stipulation, we email the parties to verify, do you need an order? Now, in theory, the motion should say that. That would be a tip-off as well that would occur. I think another time when there could be an unopposed motion would be any time when it's a good idea and there's been resolution of the issues resulting in cancellation of the final hearing. There's several cases out there where a cancellation of a final hearing was made based on representations of attorneys, and that didn't happen, or there was not agreement, and so I think that when you can summarize the stipulations into a document and it's resolving a hearing, to me that's a significant enough matter that I have no problem at all entering an order. I don't have a problem entering an order on any stipulation. It's just not necessary unless the parties indicate that it's important, or if it's something that's canceling a hearing that you want it on the record. Keep in mind, if there's an order entered, there's something that's enforceable. If there's a stipulation entered, you're going to have a hard time getting a rule Neeson through if that becomes the point of dispute, because you're now going to have to come back to the judge of compensation claim, get an order entered for it not to be complied with in order for it to trigger the rule Neeson. So just some various factors. If some people live on a handshake and you trust the handshake much more than you would any stipulation that could be reached. But unfortunately, that's not always the rule in every situation.
Okay. And we're all familiar with a rule that provides that if time allows, a party has 15 days to respond to a motion they oppose, or it's shortened to 4 days to respond to a motion to expedite discovery or expedite the final hearing. The question would be for the practitioner, starting with Attorney Hyde and Attorney Stein. Do you always try to file a response to a motion you oppose?
Absolutely. Especially if I've got an advanced notion of it before it actually gets filed, I'm already preparing. Definitely.
All right, Attorney Stein?
I draft my response when I get the motion, if I get it in advance. If I know that I'm opposing it, then we're right at issue. It's easy. It's better to do it right then anyway.
Yeah. Yeah, it's fresh in your mind.
Mm-hmm.
Well,
exactly.
If there's a response being filed, it suggests that there's an objection. If you don't file that response, how's the judge supposed to know what your objection is? I mean, not every objection to a motion is self-evident. And so because it hasn't been stipulated to, the judge can't guess at what the basis is for the response. So we have to wait 15 days and to see what the response is. And on the 16th day, when no response has been filed, the judge is not usually real happy, because we could have accomplished the same thing on day one if he just said no objection. But if an objection is filed but no response is filed, that's problematic.
Yeah, I have a lot. I get that a lot with one particular attorney who never makes a good faith effort before a petition, and so I file a motion for summary final order. I send it to him. He objects, and then the 15 days goes by, and the judge enters the order dismissing the petition. It's like, what was the point? Why did you bother objecting if you weren't going to tell the judge why my motion shouldn't be granted?
The thing that's really surprising to me is also the number of discovery motions that get filed in the 30 days before the final hearing. That makes absolutely no sense to me when the things that are being requested relate to requests to produce filed 9 months, a year before, and then they get close to hearing, and all of a sudden, well, they never produce this. Well, does that mean you don't have a diary? I mean, and quite frankly, I don't know of any malpractice carrier today that will allow any law firm not to have a diary in regard to every pleading. That's on the application for the malpractice insurance. So if that's that important to the malpractice carriers, why would you go 9 months and not get a response to a request to produce? And then suddenly the week before trial, all of a sudden it's an emergency and the judge is expected to drop everything to figure out why they haven't provided a copy of the 13-week wage statement or whatever it is that is suddenly missing.
Next question is for Judge Dietz. What constitutes exceptional circumstances, and what is good cause to hold a hearing on a motion?
When I don't understand what's being asked for, I'm always going to have a hearing because I don't want to take the chance that it's my failure to understand what's going on that is going to impact the litigation between the two parties. I can tell you I'm going to ask a lot of questions at that hearing because I'm trying to get clarification as to why we're having to have a hearing. We've talked about many of those reasons. The facts weren't included. Why it's relevant to the case wasn't included. These are all issues that may. The sad part is that that's not really good cause. That's really bad cause for having to have a hearing because there wasn't the things necessary to be able to rule on those matters. I have some attorneys that every single motion that's filed, there's a request for a hearing. I haven't found that that's necessary and oftentimes, but because when I see that it's just part of their form motion, it tells me that it's not something unusual about this. It's what they do in every case. When I see somebody that doesn't have that in every single motion and there's a request, I'm going to look at that and go, well, is there some issue here that needs consideration? I think that the practitioners understand that judges were practitioners at one point too, and they understand what the issues are related to pretty much anything that's asked for, and they understand what's going on in the trenches, so to speak. And so if something needs a hearing, then we need to get a hearing done so that the parties can move on to a hearing.
Okay. And I'd ask the question, the practitioner, starting with Attorney Stein, when do you feel it's necessary to have a hearing on a motion?
When the judges automatically set a hearing on a motion, there's a big lump in my throat. I worry about what it is I failed to do in my pleading, whatever it may have been, either the response or the motion, that caused the need for a hearing. The bulk of the hearings that we have, I don't think should require a bulk of the motions that we present. I don't think require hearings. I don't think the judge needs to hear my dulcet tones, arguing discovery motions, or other details. And if they really are that complicated in the motion itself, I can understand asking. But I can tell Judge Dietz, I've never filed a motion that says that I want a hearing on this motion. Because if I can't, I got to be able to explain it in my motion. And if I can't, then there's something wrong.
Let me just comment about that. The one thing that we saw drop dramatically during COVID when everything had to be done virtually was the number of motion hearings. I saw a dramatic drop off. I had the same number of final hearings. I had the same, there were certain things, there were certainly as many joint petition hearings on unrepresented claimants, maybe more so than usual. There were certain things that were, but the number of motion hearings dropped off significantly. And why was that? Because everybody was more concerned with doing things that were more important in their lives and practice. And that to me was very interesting, that was the consequence of COVID to the practice in front of me, was the drop off of motion hearings, not any other aspect of the case. I'm proud of the fact we never missed a day. The OJCCs, we didn't miss a day. And every settlement got processed and money got in the hands of the people that needed to get it. The system continued to work. People could get to final hearings and have final hearings. That's a statement. You look around and find any other governmental system that worked flawlessly during this, I'm going to suggest that you're going to have a hard time finding it. But OJCC worked pretty well during all this time, regardless of the challenges. But there was a big drop off in the motion hearings.
Okay. All right. The next question, again, is addressed to Judge Dietz. What constitutes effective advocacy at a motion hearing?
Well, I need to understand why the hearing has been set and the parties addressing the issues that are relevant to the ruling. I don't need a 10-minute history of the case. If it's something that has been before me before, I pulled the notes from the prior hearings. I've looked those over in addition to the pleadings for this hearing so that I can get the context of what is going on to see if is this a continuation of a prior issue. All of that is done in advance. So to me, what's effective in a motion hearing is what's effective anywhere. Tell me what I need to know. Tell me why it's relevant. Give me the authority, whether it's an administrative rule or a case. Cite to the record. Let me know immediately where I can go to get the answer, and that's effective.
Okay, and then the same question to our two practitioners. I know the answer may be that you shouldn't have to go to a motion hearing because your motion or response will be drafted so well that it's not necessary. But if you have to go to a motion hearing, what can you do to be effective as a representative of your client? Attorney Hyde, I guess.
Well, I think I'm like Judge Dietz. I don't think we should have a lot of motion hearings. And if the hearing's being set because the judge isn't certain what's going on, then, and I know most motion hearings start, decide it's your motion, do you have anything to add? And most of the time the answer is no, because it's in my motion. And so then I guess my question would be wouldn't it be better if a motion hearing has to occur because the judge has a question? Wouldn't the judge just ask the question, or does it have to be both parties first and then the judge asks questions? I guess I don't think most motion hearings need to have a hearing. Most motions need to have a hearing.
Okay, Attorney Stein.
Back in my appellate days, there used to be a certain time that was set aside for your oral argument. And there are many cases that I handled, more than 6, where I got up to go argue my point. And the moment I introduced myself and I said, may it please the court, I got interrupted by the judge saying to me, Mr. Stein, we understand your argument. Well, you can sit down. And, I was kind of shocked and worried. But in every one of those appeals, I was successful because apparently I got my point across. And I also watched them hammer the opposing counsel. And then I kind of got a clear picture of what it was. So, I like to speak very little if I can get away with it.
Okay. And the next topic is going to be a motion.
By the way, on that point, one of my favorite lines at the end of a hearing is when one of the attorneys hasn't said a word during the entire hearing. I always congratulate them on being so convincing.
Thank you for being so succinct.
Next topic is motion for continuances. And I've got 3 different points I'll ask Judge Dietz to address. We're trying to move forward in our outline, but First is difference in the motion for continuance and motion to reschedule. What are proper grounds for continuance, number 2, and then number 3, should a proposed date for a new hearing be obtained and listed in the motion for continuance? Judge Dietz?
Yeah, we see these a lot. First of all, the difference between the two is the 210-day deadline, the statutory limit. Anything that's short of 210 is a reschedule. Anything that's over 210 requires a waiver if it's being filed by the claimant, but it puts it past the statutory deadline for having a hearing. And of course, it raises some questions. If you just want to reschedule, we see a lot of those when the first scheduling of hearing goes out as notice, and the attorney realizes, oh, I have another hearing at the same time. And so we get a lot of the reschedule. That's just moving it a day or two. The second kind of motions that we get with this are and especially during COVID, which when doctors' offices weren't open, and you couldn't get testimony. And doctors that were IMEs, even doctors that were EMAs, their offices were closed. So how are you supposed to get evidence, take depositions? And so sometimes that requires going past the 210. If it's not the attorney's fault for doing it, and certainly COVID in and of itself was not an excuse that should be blamed to the attorneys, and quite frankly, we worked very hard to make sure that there was no impact on the ongoing litigation, then continuances were required. The main problems I see with motions for continuance is a biblical lineage. The first one begats the second one begats the third one, and so on and on and on. And the question is, when does that stop, and when do you say enough is enough? And so that's really the challenge to me of motions for continuance. But you can quote me on that, biblical lineage.
I like that. I'm gonna have to write that down.
Any other thoughts on the motion for continuance on those 3 questions?
Well, I think most of the judge's offices require you to get a date before you file your motion, if it's available. But and again, this goes back to me being a defense attorney. If you have filed a petition for benefits that are right due and owing, and COVID aside, I don't understand how you can't be ready in 210 days. So I get upset with multiple continuances from my side because I'm thinking it's your claim. What's going on that you can't seem to get it together to bring it before the judge? So I get annoyed at those. Well,
and that's a good question for Attorney Stein. Isn't it better practice to start looking at scheduling your deposition shortly after you file a petition for benefits?
I'm already thinking about how I'm trying the case on the day that I filed the petition for benefits. It's a beautiful system. 210 days from the date I file my petition, I'm going to be in final hearing, and I know it. And that's a beautiful thing. It really is. If you're handling a claimant's case, you want to pursue that case and push it forward. There is no better system that I have ever practiced with than this system, because the issues will get resolved. And as judges in the past have told me, the reality is that 90% of the time those issues are going to resolve and they're not going to get tried. So I don't file a lot of continuances, and when a continuance comes up, it's because something flaky has occurred, that their pretrial filed, 45 days before final hearing lists out 3 other potential employers who were on the same construction site, and now all those parties have to be brought in, and it would be worthless to try a case against one employer when we now have 3 more who may in fact be the proper party. So it would be a waste. So that would be a proper time for that. I don't want to explain to my client that we have to waive the statutory requirements that the other side has to live with. And typically those are cases where my people aren't being paid. So they're desperate. And I think, that fire in our belly must be there as a claimant attorney.
The logistical problem is that not everybody takes the approach Mr. Stein takes in getting ready for the final hearing and starting when the petition is filed. The problem is we have a lot of attorneys that don't start scheduling discovery or don't start scheduling depositions till after the mediation.
Right.
And the trouble is you've just shrunk by 130 days out of that 210, and now you're beginning the taking of depositions. And now when you try to schedule an IME, it now may be the doctor can't see him till 30 days or less before the final hearing. And then when you go to set the deposition of the IME, oh, all of a sudden it's past the date of the final hearing. And I can tell you the bane of my existence is post-hearing deposition. I swore when I started I would never grant one. I allowed one time, and I swore again I would never again do it because of the problems created. It is a nightmare, not the least of which, as of the date of the final hearing, the 30 days have begun running on the judge getting a final order finished. But here's the bigger problem. How do you argue your case at the final hearing when you don't know what somebody's going to say? That's what the logistical problem is. And yes, we can schedule a closing argument after that, but now we've created 2 additional things happening after the date of the final hearing. And it creates more problems than it's worth. And so that, and the problem is that people don't want to schedule depositions and IMEs. They don't want the expense. They don't want the cost. We can appreciate everybody trying to be efficient with costs and trying to reduce costs. But the bottom line is it costs money to litigate cases. And if you need an IME and you need a doctor deposition of the authorized doctor, these things have to be scheduled before the mediation, or there's a chance that you're not going to be able to get everything you need in before the final hearing.
All right, very good. Let me, I'm going to skip ahead to the last topic, which is pretrial stipulations, because I think probably everybody agrees that's the most important document usually in any case that's litigated. And then we'll come back to the middle part of our outline, time permitting. But, as far as a pretrial stipulation, how important is it that you take your time and list in detail defenses, claims, responses to defenses, affirmative defenses, avoidances? How important is that? Attorney Hyde?
Vitally. I mean, the pretrial governs. It's your gospel. I practiced against too many claimants attorneys who never looked at the pretrial. Their staff filled it out and then they signed it, and then they didn't look at it again until a month before hearing. And while I've been happy to have prevailed on those cases with my clients, I think they do a great disservice to their clients by not paying attention to it. And one of the things we talked about a couple of days ago when we were getting ready for this was that there's too many forms out there of, if you don't read the fine print, you can find yourself in a lot of trouble. And so we're asking Berry as a member of the Rules Committee, not that it's going to get passed, but bring that up. We need a uniform form where everything's on there, because I think one of the issues that's really important is stating witnesses, and there's a space to object, and you need to object affirmatively and state that. I know the case doesn't support me, that Clareson case, but the pretrial is everything. I mean, that's what tells the judge what the issues are. Affirmative defenses. I mean, it's everything. And no one touches my pretrials but me, except when I'm done and I hand it to my assistant to scan an e-file. They don't come to my desk pre-prepared.
Well, Ms. Hyde is far too young to remember the cattle call days of the 80s, but you'd go in and shotgun every defense known to man, and whether you knew who witnesses were or whoever, it'd work itself out over time. That's a formula for malpractice today. If you're picking the pretrial up and it's due in 30 minutes, there is no way you can adequately fill it out, and especially with the change in the role of affirmative defenses and specificity. Right. That's totally different than it was in the 1980s and even the 1990s. And so the progression that we've seen regarding specificity in regard to affirmative defenses, it may take some time to prepare that document so that it can pass muster.
And this is a question for Attorney Stein. Is it a matter of professional courtesy that a claimant's attorney attempt to get the pretrial to the employer carriers attorney at least 14 days prior to the day of the pretrial hearing?
Yes, please.
Tracey said that she prepares her pretrials. Well, I prepare my pretrials. Nobody in my office even would know how to prepare a pretrial. My staff has never been trained to do it. I'm the only one that touches them. and therefore the information contained in there is mine. If I screw it up, it's me. If I don't, then I've done it right. And because of that, I always get them done. Maybe not 14 days. You know, sometimes the mediation hasn't even occurred and we haven't honed in, but I get them at least a week in advance. But I will tell you that the bulk of the defense attorneys don't get them back to me. I get them back. The pretrial is listed, you know, on the time frame for it. It's 2 o'clock on a given day, and I get it back at 1 o'clock that day. You know, scrambling to try to finish my responses to their responses in order to get it in, and then I have to call the judge's office and ask for a convenience to move it to the next day, so that I can actually respond. So yes, I do, but most of the time, defense attorneys don't get it back to me.
And Attorney Hyde, are those timelines of 14 days and 7 days important to you as well?
Oh, absolutely. I want time to do it. And unfortunately up here, opposite of Berry, I usually get it from the claimant's attorney after the, I'm supposed to be sending it back to them and I still don't have it from them yet. And so I'll say, hey, the pretrial was due to me last Thursday. Are you going to get it to me? I'd like to have time to get it done, but a lot too late. I mean, I think that's very important. I was very glad when that rule came out, and it's unfortunate that there's no teeth to it, that failing to abide by it doesn't result in any consequences. But yeah, I get mine done on time, but I'm usually having to push the claimant's attorney to get his portion of me.
And Judge Dietz, any comment on that timeline? Okay.
Well, I mean, the challenge is that you have to read every line, and if you don't, you're risking malpractice. I mean, and that's the challenge for any practitioner. And those offices that have staff doing it, it's even a bigger risk. So, you know, you need time to be able to fill it in. You know, the people that get it, send it back at 4:55 and it was due at 5 o'clock, that's not realistic.
Right.
And as a practical matter, all the attorney has to do is let my office know, and we would be willing and certainly grant the ability for them to be able to complete the pretrial when that's the fact pattern. But do you really want me to set a hearing on the issue of why a party didn't return the pretrial timely, such that it created a problem for the other side? I mean, that's not the kind of hearing. I mean, there's several kinds of hearings that to me never are going to occur. And one of them is the hearing that relates to the issue of why a party doesn't return a phone call in order to set a deposition. Okay. And that comes up in regard to unilaterally set depositions. Well, why should you unilaterally set a depo? Because they never returned my call. Well, then don't unilaterally set the depo, file a motion for determination as to why the party won't return the call. I got news for you. We set that hearing every time. I'm still waiting for the first hearing on that. Never has the phone been picked up so fast, because no attorney wants to appear in front of a judge to explain why they never return a phone call. So on the other hand, I do not want hearings on unilaterally set depo. The first month I was a judge, I had 3 of them filed, and it became very apparent I could spend the rest of my life as a judge dealing with unilaterally set depos, or we're going to lay out some ground rules, and that is they're not going to be unilaterally set depos. And so instead, I propose you file a motion to explain why you've not returned the call necessary to schedule the depo. And guess what? No more unilaterally set depos.
All right. And that brings up a good point that so others have referenced here, that we need to read, or the practitioners need to read every word that's on the pretrial stipulation, because you may be agreeing to some boilerplate language that you don't approve of. And a case that we've discussed in this group is Citrus World versus Mullen, 704 Southern 2nd 128, Florida 1st DCA 1997, where a deposition of an unauthorized physician was admissible, where the party stipulated the admissibility of all properly filed and notice depositions. So it's important that you read every word, including what's typed in and not written by either attorney.
Another thing that changes on the pretrials has to do with average weekly wages. There were form pretrials that said, number one, the 13-week wage statement was to be attached to the pretrial. I think I've seen that occur maybe twice in 7 years. And the second thing is that it's to be filed within 5 days of the pretrial. And again, they never are. But that's a place that there are differences in the language that appears on the pretrial, which you have to be very careful of.
All right, and the next issue is, and I'll address this to Attorney Hyde first. If you do not object to either exhibits or witnesses listed on the pretrial stipulation, does that mean you've waived any objections to such exhibits and witnesses?
I would argue yes, that you need to affirmatively check the box. I know what Clareson says. I know what Judge Walker recently ruled in that Hadaway case, but I think that's just gotcha. Why, and Judge Dietz will love this one, why would I need to set a hearing on my pretrial to clarify whether the other side objects or not? It would just seem to me that so much, I mean, that's the whole point of the pretrial, is to narrow the issues and let the judge know what's going on. So I want the form to read that you have to affirmatively object and state the reasons for your objections. So I understand at least one case is not in my favor. And again, it's going to depend on what pretrial form you use as to whether that language is on there. Because I just filled out a couple this week that had that language on there, that you had to affirmatively object. And so other forms don't have that. And that's where Clareson came from and what happened in the Hadaway case. So we'll follow it around on appeal and see what happens. But I mean, I think that's your time to be responsible and tell the judge whether you object to certain things coming in, so that if the other side has to get those records custodian depos or whatever it is that you're objecting to, they have time to do it. I mean, we're supposed to be a congenial group. I don't like the gotcha stuff of getting the final hearing and go, oh, I object, judge, they could have brought all those witnesses live. Really?
Excellent. We're running a little bit low on time, so I'm just going to sort of summarize the documentation to be submitted for a settlement. Everybody knows this, but motion to approve attorney's fees, you need the motion, the attorney fee data sheet, the cost reimbursement data sheet with itemization of cost over $250, a sworn statement about existing child support, including any out-of-state child support arrears that exist, affidavit of residency. If multiple child support exists, the rules require you to prorate it between accounts. If a miles fee is sought on the settlement, then the contract that permits a miles fee and a separate waiver, if there's a waiver, if not, it'll be in the contract, and an attorney fee affidavit. Question for the practitioner, starting with Attorney Stein: if the settlement, should the settlement documents reference a time of payment of the settlement proceeds, and should any language be added regarding possible penalties and interest if the settlement is not paid timely? Attorney Stein?
Well, by statute, the reality is that penalties don't apply on the settlement. If penalties are to apply, the parties would have to write it in. Interest should apply. And I oftentimes write in the exact language that I want with regard to the payment time. You know, counsel puts 30, I cross it out, put 14. They have all different phraseologies, from the date of the order, from the date they received the order. You know, I read the settlement packages like I read pretrials, line to line, to make sure that I'm not getting something that's I'm gonna miss and screw up on also. And settlements are handled very differently all over the state. From, you know, Miami to Pensacola, they are not the same, and the judge's review of those is not the same. And so I like to think that I'm in a district mostly where they're very detailed, sometimes too detailed, and we try our best to meet the requirements. I told this this august body when we were talking about how I submitted a bunch of settlements in December. And I was so excited because I got my orders back from all those settlements, which meant that I had all those papers that were required. So it's a detailed process, and we need to make sure that we provide what's needed. I would like the judge's offices to be more consistent, and they're not.
All right. And again, skipping ahead a little bit to, go ahead.
I think there's two issues that float around. The issue regarding multiple child support account exists, where I think if it's only prorated, I have no problem with doing that. But I have attorneys all the time that want to set aside this one and that one, but only pay it to this one or that one. And if it's anything other than prorated division, I'm not interested in, that needs to go to a court of competent jurisdiction. And whoever has priority and has jurisdiction over the child care issues. I'm not a court of competent jurisdiction to address child care disputes. And the other thing has to do with almost on a weekly basis, somebody says, oh, well, I don't really owe the child support arrearage. And the attorney wants us to set that aside. No, we don't have the ability to do that. However, we will be happy to put the amount of the child support that should have been paid and put it in escrow. And you have 60 or 90 days in order to fix it, at which point the money should be paid to the division, to the appropriate party if it has not been corrected. I have no problem with doing that. So the rest of the settlement, the other disputed part or the undisputed parts of the settlement can be paid.
All right. And again, skipping ahead to stipulations, how important is it to take your time and draft a stipulation that exactly comports with what your client is agreeing to do, Attorney Hyde?
Language is important. There's quite a few recent cases that have come out that says you failed on the 120-day rule because you stipulated to the back. And so all of those degenerative disc disease and arthritis and everything else becomes compensable. So you really need to be specific on what you're agreeing to not lock yourself into something you didn't plan on.
Okay, Attorney Stein?
You can't say it better than that. You know, you got to both, you need to both understand what it is you're doing. There has to be a meeting of the minds. That's what the stipulation is all about.
I love it when I read a stipulation and the first response to what's stated there, oh, we're going to be litigating that 3 months from now. That means it wasn't clear. That means it wasn't spelled out properly. And, you know, you read it and it's just like, oh boy.
All right. And hopefully this will be on the outline, at least 3 of these cases, but I'll give you these sites real quick because we're running out of time. Marin versus Aaron's Rent-Owned, 53 Southern 3rd, 1048. Marin, it's 53 Southern 3rd, 1048. Then Salinas versus CAT Concrete, 46 Southern 3rd, 600, 46 Southern 3rd, 600. Salzman versus Reyes, 198 Southern 3rd, 1068. 198 Southern 3rd, 1068. And then a couple other cases on stipulations. They're both in a modification setting. Griffin versus Orlando Regional Medical Center, 578 Southern 2nd, 448. 578 Southern 2nd, 448. And then Florida Power Corporation versus Hamilton, 657 Southern 2nd, 1260. 657 Southern 2nd, 1260. And then probably our last topic real quick is motion to admit medical records. Attorney Stein, how should that properly be done?
Pursuant to the rule. I mean, we have it, let's use it and make it efficient. Honestly, I just filed one today. My final hearing is in May. Part of the reason for my filing it now is to know whether I have a dispute with regard to the records I need in, because if I have a dispute, I need to go ahead and take a deposition of the physician. But if I don't have a dispute, then I don't need the depo. And the only way I could figure it out, now again, it's counsel who's not necessarily responding, so it makes it a little more difficult. But, you know, get it out, file it, and I always talk about how I'm really archaic. So everybody talks to me about how Adobe can give you the bait stamp documents. And I literally have a bait stamper, and I sit there hacking away at my 200 pages of medical records that I'm doing. But there's something very satisfying for this old fart about doing that.
All right. And I think we're out of time, and thank you very much for viewing. And there will probably be a time to ask questions. There may be a time to ask questions during the presentation we were watching. But we will be available to answer those during the presentation. And thank you all very much.
Thank you.
Thanks for